So a question
Yeah,
came in on the YouTube comment section around affordability, and it's a very smart question because it was not only asking about the definition of affordability itself, but there was then kind of the implications. I think one of the parts of the question was, if you're in unaffordable accommodation, if you're homeless at home, what does a council actually need to do? Can you make a homeless application? So I think it would be helpful just to kind of look at that definition of affordability itself, and then look at how that kind of definition is then plays out within different parts of a homeless application process.
yeah. So just to dive in there, the starting point is if you have an affordable accommodation, or if you've got any other problem with accommodation, my advice would be apply to the council for assistance. We've moved away from the days when you actually had to be street homeless in order for the council to house you as a homeless person. They now have a duty to assist you with a sort of quite a wide range of housing problems, one of which is to stop being made homeless. And obviously that's maybe your first thought when you've got an affordable accommodation is, I'd like to stay here, what can I do? So that would, if I start there and say that they could assess you and see whether they can do anything under their prevention duty, which is a duty to prevent you from becoming homeless, which came in the 2017 Homelessness Reduction Act. Now, there's not a lot they can do, because at the end of the day, if you can't afford to pay the rent, they can't say to you, well, we'll make up the difference, because that undermines the whole housing benefit system, because it's assessed and the government set all these levels and things. They can do it temporarily. So, for instance, a common example would be somebody's children grow up and they move out, and they've got a 3-bedroom flat, and they get their benefits capped because there's only one of them living in there now, and so the council themselves issue possession proceedings, and the council, you can then say to the council, well, can you pay me discretionary housing payments? I will apply to downsize to a smaller property. And this is important because that would be a smaller council property, which the council could offer you. Because remember, at the beginning of all this stuff with David Cameron, the idea was that they would cap benefits because people would then, the bedroom tax now was designed to stop people living in properties that were too big. And then these sort of homeless families could move in and the other people could move into smaller places. The big mistake with that was there weren't any smaller places. Because they'd sold them or they just weren't around. But nevertheless, you can say to the council, please, can you help me to downsize to another place? And can you pay me discretionary housing payments to make up the shortfall until you find somewhere? So that's a nice arrangement.
And it's certainly a lot of the allocation schemes I've seen, you often, like, the highest banding will, be extreme domestic abuse, and it will also be under occupying because it's in the council's interest to move you somewhere which is smaller, which then, as you say, frees up the property for a larger family. So actually, I guess the question here is, are we talking part 6 here or part 7? My natural inclination is to treat everything as a part 7 application, which I know isn't
Yeah, I
always the
think
right
that's the
fit,
right
but
thing to do.
yeah. So I think that's probably, as you say, asking for assistance, and there's reasons to believe you might be homeless. You're therefore triggering Section 184, and that can then motivate them. I've also seen it where, and I talk about this example in the training I do, is an individual applies for a DHP separately themselves, not knowing the system, and they get turned down for it. They then make a homeless application, and then the housing officer says, right, well, we'll just get a DHP through, talks to their colleague 2 desks away, and it's all okay. So it's almost like using a homeless application as leverage, really, to get a more, a better outcome for the individual.
Definitely. And there's 2 extra things to bear in mind with that. One is, if the council or somebody else is issuing possession proceedings, you've got a good defence to put in the proceedings to say, I'm in the process of doing this, and a judge in the county court will say, well, we'll adjourn. Usually they should say, we'll adjourn the proceedings until this is resolved, because we need to be satisfied that it's reasonable to make a possession order. And another point is, not only can they pay, whilst they can't make indefinite payments of discretionary housing payments to top up the rent, they can make very large payments to clear rent arrears. So that if somebody has had a problem where they didn't realise, or they had to change from housing benefit to universal credit housing costs, and for whatever reason there was a gap where nothing was paid for 6 months, and they've suddenly got several grand rent arrears, the council can pay that. And I've seen it happen, and I was amazed. They can write it off.
Yeah, so that's we see it quite frequently, because also it can also potentially be a barrier for people getting rehoused. So once the main homeless duty has been accepted, a lot of so we don't have any council stock in Bedford. So all the housing associations will almost have a blanket policy saying you've got rent arrears, we won't even think about housing you. So the council will then, as you say, pay up. I think we've seen like £5,000 being paid off. But it's another example, I think, just to kind of labour this point of if you went into a council and said, "Can you pay my rent arrears?" They'd be like, on your bike. If you say, "Can I make a homeless application because of this stuff?" Actually, it's then in their interest to make that payment
Yeah.
and kind of help you out. So I guess it's that emphasises that issue of, affordability is a homelessness issue. It's an issue which you want to be getting assistance under the Housing Act, not just asking for sort of ad hoc support from a council, because you won't get it. Probably, well, in my experience, you won't get it unless you ask for it in the right way.
Yeah, it's a really good effect of one of the many really good effects of the Homelessness Reduction Act is that the discretionary housing payments, I think, were already there. But as you say, if you went and asked for one yourself, you just get rejected usually. But now the council have a duty to assess your needs and come up with a plan for helping you. So even if they don't say, "Oh yeah, we'll make a discretionary housing payment application," you could, if you wanted to challenge what they were doing, you could say, "Well, you should have helped me do this." And they can also help with the Part 6 stuff as well. Because again, many people find applying for stuff under Part 6 very difficult. You've got to understand what the allocation policy says. You've got to get through the bureaucracy of making the application, and then know. And then when they tell you you may get an offer in 5 years, you've got to know whether they're right or wrong. So if you get to somebody in doing a Part 7 application to help you with that, that's very good. So yeah. I think that, so to go back to that point, if you've got unaffordable accommodation and it looks like you might lose it and you don't want to lose it, applying to the council for assistance on the basis that you're at risk of homelessness is a very good thing to do, and it can make all the difference.
There was I think it is probably worth just kind of giving as much detail as possible on this. So there's an LGO case which I think predates the HRA, but I'll stick a link somewhere on this. And basically, this guy, he lived in a caravan park, I think, and he knew, because of his financial situation, he knew that in a few months' time he was definitely going to be evicted. Like, I think he applied in November, and he knew, and everyone accepted he was going to be out in February. And the sums were ridiculous. He was like, he was £1,000, like, under what he needed to actually maintain the accommodation there. And the LGO upheld the complaint, and they said that basically, because what the council said predictably was, we'll come back in February when you kicked out. And the LGO said, no, hang on a minute, you've missed the fact that this guy was already homeless because he was in unaffordable accommodation there and then in November, and therefore they should have treated it differently rather than waiting till and advising to wait till.
Yes, you're quite right. Actually, I missed that as well just now because I didn't include that. Because if the council, having carried out their assessment, say sorry, there's nothing we can do, then they would be obliged to recognise that he's homeless because he has accommodation which is unreasonable to continue to occupy. Although then again, it goes back to what we were saying about overcrowding, because they might say, well, we think it's reasonable to continue to occupy because we think a debt, given the demands on housing in the area, is sufficient. But it'd be worth having a go at.
This brings us to this actual, what is the definition itself? How would someone know, given their income and their expenditure and the rent, how would they know that they're actually in unaffordable accommodation?
This is a really good question, and one which caused a lot of problems for many, many years for people doing homelessness law challenges, because there wasn't one. There was no rule, and it just came down to the subjective views of housing officers and reviewing officers, which would be motivated by a desire to refuse to assist the person. So you would get a situation where, and it usually came up in intent, traditionally it wouldn't even arise at the "I'm at risk of losing my home" bit, because they'd say, well, sorry, we don't even engage with you till you've lost it. So come back when you've got the bailiff's warrant. So when they get the bailiff's warrant, they then come back and they're told they're intentionally homeless because they lost their home due to rent arrears. And then they would challenge it and say, well, I couldn't afford to pay it. And then you would get into this ridiculous sort of argument about, oh, yes, you could have paid it, because if you only ate half as much as you did, then you could have afforded it. And there'd be all these review letters where the reviewing officer would say, I've worked out that your income for your universal credit and your PHP and your child benefit, it comes to this. And if you take all the stuff away, you're left with whatever, and you could have used that. And it just became ridiculous. And you get, who's that Lee Anderson, 35p Lee.
Yeah.
He would now, you would get people like him saying, what a lot of nonsense. You can eat for 35p a meal. So there's no need for you to have all that universal credit, and you could be spending that on paying £50 a month towards your rent. And
The first case we ever got upheld by the LGO was part of the issue was affordability, and basically this guy he was in he was in private rented accommodation and he had to top up the rent I think by £20 a week or £15 a week, and he had like child maintenance payments going out. He had a lot of debts which he had to pay. And I remember the wording of the second stage complaint response was, he just needs to budget more carefully. That was their argument. And as I say, the LGO upheld it and they paid compensation in the end. And it reminded me of another case actually, which went to housing reviews back. And I think this was before HRA, around about the time HRA came in actually, so beginning of 2018 maybe. And this guy, he was in again private rented accommodation, and the issue was he intentionally homeless? And this was a guy who long history of homelessness, a lot of issues going on. He had very serious health issues, which he needed to go to the doctor regularly for. And he had to pay for a taxi because he couldn't walk. And I remember going to and fro between housing reviews and myself. And every time I submitted, more evidence to say, look, these are all the appointments he's attended. This is how much it costs from a taxi. They take that all on board, and then they kind of just change their own sums and say, well, actually, if you save this money over here again, that was a case where Bedford Borough Council actually dismissed what Housing Reviews Limited say, and they just basically said, look, we can see that actually this guy can't afford his accommodation, so he's not intentionally homeless, and it was a really good outcome because he's still housed actually many years later. But yeah, I think that's the sort of situation we see it in.
It led to increasingly childish arguments like that, was sort of, oh well, you can afford to live, and then your children shouldn't have any sort of fun in life, and if you take them to McDonald's, that shows a sort of waste of money. So this all came to a head because the other question from a legal point of view is that although it's frustrating to get this sort of nonsense being argued about, and judges didn't really want to see all this sort of stuff in front of them, the question was, if you applied to, I don't know, Lambeth, you get reviewing officer in Lambeth, and they've got their own views about what is affordability and budgeting, and then you go somewhere else, you got somebody else, and there was no objective rules. And this all came to a head in a case called Samuels in the Court of Appeal. I think it was 2018, and what the court there said there was they really do. You can't just sort of do your own sort of, I think that this is, me, I'm the reviewing officer, I think this. You have to actually refer to something. And the background to this is that the benefit system is designed to provide subsistence. It's not designed to provide you with a sort of portfolio of money to spend on other things. And so that they've calculated it as that's what you need to live on. And in Samuels, they said you've really got to have an objective set of values for working out what is affordable. But the problem was they didn't have one, and the court didn't feel able to sort of pronounce on what that was and draw up a sort of schedule to the judgment. And so they amended the Code of Guidance after that case. And so now at paragraph 17? Code of Guidance says that they should make reference to the universal credit allowances. And so
I remember when
that
case came in, because that made it so good for so many homeless people, because people's finances are actually very stark a lot of the time when you look at it in that kind of hard way. But I was kind of really gutted when the kind of most recent case, the Baptiste case, came in, which kind of undermines that, because there was a point where it was like, the DWP figures, that's it, that's really the end of it, that's the end of the argument, or not even that, like that's just that's the baseline that councils have to use, and then you can add in, someone that needs to get to a GP via taxi regularly, then you just add that figure on, even to make it even more kind of obvious that there's the property is unaffordable. But I think the Baptiste case seems to me to make it more complicated again, which is a bit of a kicker.
Yes, it
really
did, and forgive me, I mean, we could look into that in more detail, because I'm aware of that case, but I don't think it undermines the essential principle that which is that there has to be, I mean, you have to make reference to these basic allowances, and you can't just say, well, in my day, you know, you could go out on a Saturday night for sixpence and all this sort of stuff. So that's the answer to how you assess affordability with reference to those. I mean, there will be still scope for lots of argument.
I mean, do you want to talk about the AHAS figures that the AHAS research? Do you ever use those figures on the? Because we find it
Well,
quite helpful.
I don't really feel qualified to talk about them. I did see they were mentioned in the Samuels case,
Yep.
but for reasons I'm not entirely sure of, I think they were competing. There were about three different sets of scales or whatever, or systems for evaluating what was a subsistence, what you could live on, and that was one of them, wasn't it? And
yeah,
because I think Shelter or the Child Poverty Action Group intervened in that case and came up with a lot of data. And I think the judges still felt a bit overwhelmed by it all and didn't want to get into sort of prescribing what's the sort of thing you get in a statutory instrument. So that's why they were quiet on it. And I think maybe, it is probably better just to say you should have reference to the universal credit rates, because are those guidances like the AHAS ones specifically designed to establish what people can live on? Or?
Yeah, so they, I mean, they're referenced in the BAPT case. I think, I might just be imagining this. I'm pretty sure the judge basically said, you know, AHAS does, you know, pretty robust research, but because at the time, you know, inflation was already rocketing, they basically on the AHAS website for a while, it basically said,
oh, that's right, yeah.
these figures are already out of date. I think they were updated most recently in December, but again, you know, if I was advocating for someone, I'd be getting those figures and then working out what inflation has been since then, and just, you know, adding that percentage on. But certainly they'd say, I think the current figures are something like £28 is enough to pay for someone's food for a week. So if you've got a family of two, then it'll be £56 per week. So you kind of end up having to kind of break down a lot of these figures, you know, utility bills. You kind of say, well, this is what it should be, but actually you use your actual figures that you've got. So certainly I've done a lot of casework where you're literally doing that maths, and then you kind of have that baseline, you know, and I think stuff like, you know, £8 a week is enough to save up for white goods, and so you've got these kind of quite wide ranging figures. But then you go to the individual circumstances, whereas I say, if you've got someone who's doing 2 taxi rides to a GP every week, then you add those figures in, and you add that in. So that's how I've used them before. I've only glanced at the most recent numbers, but I think, as I say, I think £28 is kind of a starting point for food, and you've got travel, you've got clothes, you've got TV license, you've got mobile phones and broadband. Can't remember what else, but stuff like that basically. And certainly, again, my experience with councils is they'll refer to that and they'll use that as, they'll kind of take that as read. But I'm assuming that not all councils do. Well, obviously, not all councils do, but yeah, that's been quite helpful.
Before Samuels, I was dealing with quite a lot of affordability cases, and I haven't hardly dealt with any since then. And I think reviewing officers realise that the scope for them to make perverse decisions which they can get away with has gone now.
Yeah. I think you're right. I think it was a really good case for the, you know, for the person who's actually in that situation. It was a good one to kind of go in their favour.
Although one should never underestimate the ability of reviewing officers to make perverse decisions. And I don't mean to be mean, but
I think it's important to say. I mean, you know, there's, as I say, I mean, my experience of Bedford recently, that is where obviously my focus of my work is they're pretty good. You know, there are still a few ones which you think are a bit dodgy, but you know, when I deal with cases outside of Bedford Borough, which, you know, they've improved massively, it's shocking, you know, what sort of stuff happens. I think it is important just to recognise that actually some housing officers out there are really bad. You know, lots of housing officers are really good, but there are some bad ones.
I'll give you an example. I've been sort of amazed at it. It's a case called Tapper. I'll put it on my blog, and it's on Nearly Legal, but it involves Kingston Council, where the person representing the applicant asked the reviewing officer for some time to make representations. So I think they asked for a week, and the reviewing officer said, no, I will only allow you 1 day. And then after 3 days, they sent the reps in. They hadn't made the decision yet, but the reviewing officer refused to consider the reps. And then, to make matters worse, when it came to putting their skeleton argument in for the appeal, the council were weeks late and made an application to be given permission. But as you can imagine, they sort of hit a brick wall, and the judge said, no, you should have, you should have allowed at least 2 weeks when they asked you for time, and B, how ridiculous to refuse to look at something when you have. You couldn't really make that up, could you? That they'd be that pig-headed that they wouldn't. I'm not going to look at this because you've forfeited the opportunity to.
Yeah.
But there we go. So that's how you measure affordability.
So I feel as though we've kind of already covered some of the additional questions that come out of this. So in as I said, the YouTube comment, it was kind of saying, well, look, if you're in an unaffordable accommodation, can you make a homeless application? The answer is yes. And actually, as you say, kind of under the additional duties in the HOA, the council's actually got quite a lot they can do and a lot they should do to help you out and hopefully mean that you don't lose that property. I've worked with families who have to apply for a DHB every 3 months after making an application because, as you say, they're not indefinite; they are only for a limited period. And I'm trying to think if there's any other elements of that question that came up. Let me just check my notes.
There's a good element to it, which is actually a sort of springboard into a much bigger question, which I'd be interested to talk about another day. But just to say, I think you answered the question was, if they find that your accommodation is unsuitable, is unaffordable, or you're living in unsuitable accommodation, do they have a duty to put you in temporary accommodation immediately or to rehouse you? Because basically the law seems to say that they shall secure those. If you meet these tests, they shall do this. And without going into too much detail, this has been the subject of 2 big cases this year or last year. One in relation to how quickly councils have to provide accommodation under Section 193 when they've accepted a duty, particularly to people who are homeless at home. And the second one is if you apply to the council for accommodation, how quickly do they have to give you that temporary accommodation under Section 188? And there's lots of, you've probably heard of the cases and you've dealt with where the housing officer is saying, I don't have reason to believe that you're homeless, even though you sort of tell me you're homeless. I mean, they say, oh no, you've got to prove it. And well, that's not, then you can get into a sort of ridiculous argument about, well, what's the difference between proof and reason to believe? And the question, I mean, it's a failure of the language of the statute, really, because you can't really expect the council to house immediately. To say they press the equals button on the calculator and it says, oh my God, you can't afford that. I'm going to get on the phone straight away and I'm not going to have any, I won't go home until I've sorted your temporary out. They probably say, well, we'll issue a duty, we'll issue a decision and then we'll offer you something. And the cases of El Kundi and Yabari, which are the 2 I was talking about, look into questions as to how long they should be allowed to take and what a court should do if they haven't done it. And that's really interesting.
So that might be because in the Jan Luber textbook, the most recent version, which I think is probably a year old now, it basically said there was an ongoing case which was quite been looked into in a lot of detail. It might be those cases then because it was sort of, as you say, like, is it how immediate is it? Certainly in my experience, it's particularly if you're actually out on the streets or whatever, then it should be immediate anyway, or any sort of like domestic abuse. I worked with a council recently where high risk domestic abuse case, and they took a week, and they're like, yeah, well, it's a Friday and it was a weekend. What do you expect us to do? And I was like, well, the law kind of says you have to secure accommodation immediately, particularly in that sort of situation. So I don't know. So are those cases settled now? Are they still kind of in that process?
I think the case Jan Luber was referring to may have been a case called Imam and Croydon, which was a Sarah Steinhardt case, which was part of the El Kundi appeal. It was, as with many appeals, it involved a couple of cases joined together, and Imam was one of them, and she won the appeal against the High Court judge because but the arguments still go on, and on a practical level, because you can't really. You just have to accept the English language is not good enough. It is failed in the sense that when you say shall do something, that doesn't mean immediately, but it means pretty damn soon. But the problem is once you've introduced that element of doubt, then the council will say, well, pretty soon, from our point of view, means 3 years' time. Whereas from the applicant's point of view, pretty soon means maybe I can put up with the day after tomorrow, but and any longer is too long.
was the Ibarra case? Was that the again? I'm really terrible at remembering names of cases unless I've seen them for years. But there was a case recently where the issue was the fact the temporary accommodation had the suitability of the temporary accommodation had to be reviewed all the time. Whatever obviously
Yeah,
that's
it all
again
tied up
fairly
with
different English
suitability
language.
as well.
And so if the circumstances change, then the council needs to respond to that, and they need to offer potentially alternative accommodation if something, yeah, as I say, if it's no
Yeah.
longer suitable. I don't know if that is that case or if that's just something that resembles it a
Well,
little bit.
it was something that sort of touched on, and then it also touched on the question is if the applicant is giving you not very much reason to believe, and in fact, in the course of what they're saying, you also have reason to believe that they're taking the mickey. Which unfortunately in that case, I think there was an element of that. Like he wasn't being straight with them and was claiming at one point he couldn't speak English, and then another point he was the interpreter for his family and wouldn't give them any medical records either. So you can see that they were saying, well, we've got reason not to believe you. So there was all sorts of stuff in there.
On a tangent, so before I forget, forgive me if I'm repeating myself here, Will. So I put a case in the Facebook group, Homelessness Best Practice Facebook group, which talks specifically about how the LGO looked at a case where the applicant was refusing to cooperate with the inquiries, and the LGO was like, well, it's not the council's fault if they've asked for this stuff and you refuse to give it, then the council weren't at fault in that case. So I thought that was the first time I've seen that kind of clarity on what you do when you've got someone who's refusing
Well,
to
yeah,
say who the
that,
GP is and stuff like that.
that is actually something that was on the list of things to talk about. Not that particular LGO thing, but the issue. We could talk about that very briefly because I only put a short answer to that. But
Yeah, sure.
in terms of affordability, I think that's everything. Oh no, you answered the couple of questions. So basically, if they accept that your accommodation is unaffordable, I think they are obliged to accept that you're homeless, unless they think that the debt is something you can live with. And then if they accept that you're homeless, they're then under a mandatory duty to accommodate you. And then we're into the territory of those other cases, which we'll leave for now. And then,
but so most councils I'll be aware of would they basically put DHP in at that point on day 2 or whatever, and get it cleared off, and then that person is no longer homeless, and then they'll issue a not homelessness decision, and that's how I've seen councils deal with it, which that works. That's the best of a bad situation, I'd say. As you say, I've seen families who have to reapply for a DHP every 3 months on that basis, but it's certainly better than the other alternatives, basically.
You also asked as part of the question, the supplementary bit was, do you have to give notice to your landlord if the council accept you for temporary accommodation?
This is probably more likely to come up. Say you had a situation where you had either like disrepair, where it's like category 1 hazards or something, or whether you've got domestic abuse where you're a joint tenant, you leave the property. Do you know what? Well, I think we might save that one for a different session because that's quite involved.
There's how do you terminate your own tenancy if it's you on your own, and what do you do if you've been given temporary, and the other is what if you're in an abusive relationship.
So let's do that first one now. Yeah, let's do the first one now. I think that's more straightforward. So you've got your own tenancy. You've now been offered temporary accommodation, which I think is, to say, probably less likely in this circumstance. Councils are more likely to increase your income basically to get around it. But say they have done that, you've still got tenancy, you still owe that rent amount. What can people do?
Well, there's two legal mechanisms they can use to resolve that problem. Number one is what's known as surrendering the tenancy in legal terms, and in practical terms, that means handing back the keys to the landlord, and the landlord says, "Thanks very much, I'll let you off. You're no longer my tenant, and I've got somebody else who can move in," or something like that. So you know that you're clear. But the other thing is serving a notice to quit, which I think you mentioned. You give a formal tenant's notice to quit. Now, the problem you might have is if you're in a 12-month assured short-hold tenancy and you're locked in for 12 months, so the fixed term hasn't expired, and unless the landlord agrees to terminate the tenancy through a surrender, you're stuck because the notice can't be served till the end. But so the answer to your question is you should give the landlord notice if they won't agree to a surrender, unless you want to be liable to pay lots of rent. But bear in mind, you may be liable to pay some anyway if the landlord wants to be difficult. Having said that, I tend to find that if a tenant who is homeless moves out, the landlord isn't really going to pursue them for the rent arrears. They may talk about it and threaten it, but if they go and see a solicitor and the solicitor says, well, I'd like £700, just to talk to you about this, the landlord's going to think, hang on, I've got no money coming in from this. Do I want to spend another 700? And that's what lawyers and maybe other people call throwing good money after bad. And so they probably say, well, I'm just glad that I've got the place back and I don't have to go through court proceedings. And
I've seen housing options officers essentially say that. Say, I've never seen a landlord actually come after anyone. So that
the only downside is once in my whole career I've come across some slightly psychotic landlord who was taking action to make sort of students bankrupt because they hadn't paid the rent and was seen to be going to a ridiculous level. But that was only once. And the other thing is, remember, if a landlord does get a county court judgment against you for rent arrears, I think I'm right about this, that it would count for credit status purposes. So if you ever wanted to get out a loan or something, you might find that you can't because of those rent arrears that you got when you moved out.
Yeah. So I mean, again, for the layperson, the answer is try to negotiate with your landlord, involve a housing options officer, because they should see this stuff all the time, and try to kind of come up with a situation where everyone's kind of happy with it. But then, as I say, they engage those legal mechanisms if you have to.